The Fair Housing Act prohibits discrimination in housing based on race, color, sex, religion, national origin, disability, and familial status. These are referred to as protected classes. Having a criminal record does not constitute a protected class under the Fair Housing Act. However, because African Americans and Hispanics are arrested and incarcerated at disproportionate rates, criminal records-based barriers to housing end up having a bigger impact on minority home seekers. This means that having policies or practices based on criminal records can constitute race discrimination if the policies are too broad and are not carefully implemented. Examples of policies or actions that would be considered race discrimination are: if a housing provider treats individuals with comparable criminal histories differently because of their race; if a leasing agent assists a white applicant to secure approval despite a criminal record but does not provide the same assistance to a black applicant; if a housing provider has a policy that it will not rent to anyone with a criminal charge or arrest, regardless of whether there was ever actually a conviction. The best practice is for a housing provider's policy to be narrowly tailored to accomplish a specific objective, such as tenant safety, by limiting the types of criminal convictions that they look at and by limiting the time period they will look back. If you have questions about the Fair Housing Act, you can talk to an attorney for free by calling Idaho Legal Aid at 1-844-804-0386. If you have been discriminated against, you can file a complaint with the U.S. Department of Housing and Urban Development by visiting hud.gov or by calling 1-800-669-9777.